Preliminary hearing in a reference by the Attorney General for Northern Ireland.
Yes.
My Lady, my Lords, in this preliminary hearing, I appear on behalf of the Attorney General for Northern Ireland. My learned friend, Dr McGleenan, represents the Department for Communities with Ms Curran. The Court has directed this preliminary hearing on the question whether a devolution issue arises in the reference made to this Court by the Attorney, a question put in issue by the Department in its response to the reference. My Lady, my Lords, in my submission, a devolution issue does arise for the reasons set out in the Attorney's written case, which I formally adopt. I propose to make some brief submissions in support of that case, including as to the proper approach to the construction of the expressions act and exercise of functions as they appear in the Northern Ireland Act 1998, and I will do that by reference to Her Majesty's Advocate against R and by reference to the affidavit lodged on behalf of the Department. Thereafter, I intend to address 4 specific matters arising from the Department's written case. First, whether the Department's involvement has been no more than the provision of administrative support and or the making of a recommendation. Second, in order to amount to an act for the purposes of Section 24, whether action taken by the Department must have legal effects. Third, whether those effects must be independent. And fourth, the question of the remedy which the Attorney might seek in this reference. My Lady, my Lords, the questions referred by the Attorney General are set out in the paper attached to the Notice of Appeal. They can be found at MS 13 and MS 14. Each of the questions concerns the convention compatibility of action taken by the Department in relation to the introduction of universal credit in Northern Ireland. In particular, the questions concern the role of the Department in implementing a scheme which includes what may be described in shorthand as the two-child rule, which places limits on the amount of benefits payable in respect of families which come to comprise more than 2 children.
Do we really need to get into the question of the measure?
No, my Lord, no. I was simply introducing the yes, submission by reference to the questions and to make the point that the Attorney asks the Court in relation to that two-child rule whether it breaches the convention rights of the children and the parents. Yes. By reference to Articles 8, 12 and Article 1 of Protocol 1 to the Convention, whether alone or in combination with Article 14. I was going to say a little about the relevant provisions of the Northern Ireland Act. I'm very conscious that the Court is familiar with the scheme. The relevant provisions are at tab 5 of the authorities. Section 24, on which the Attorney General relies, is at MS 595. And it provides, amongst other things, that a Northern Ireland Department has no power to do any act, so far as that act is incompatible with any of the convention rights. Now, I should say for completeness, there is a carve-out from that disability which provides that it does not apply to an act which, again using shorthand, is compelled by primary legislation. And that's under reference to Section 71 4A of the 1998 Act. And there is no suggestion that I am aware of that that provision is in play in this case. Schedule 10 to the 1998 Act deals with devolution issues, and paragraph 1B of the schedule, again on which the Attorney relies, provides that a devolution issue means, among other things, a question whether a purported or proposed exercise of a function by a Northern Ireland Department is or would be invalid by reason of Section 24. And so far as functions are concerned, I would draw the Court's attention to Section 98 of the 1998 Act, which is at MS 608.
Well, what's the MS number for paragraph one of the schedule?
It's MS 613, my lady.
613.
613.
Thank you.
And as I say, Section 98 provides that functions includes powers and duties.
Sorry, is that 508 or 608?
608,
608,
my lord.
thank you.
So the question arises, my lady, my lords, as to what it is said by the attorney was the act for the purposes of Section 24 of the 1998 Act. And as articulated in the reference, in the questions to which I made reference earlier, the Act in each case was the purported making and issuing by the Department for Communities of lists of postcodes, which had the consequence of making effective commencement orders which had been made by the Secretary of State for Work and Pensions. Now, the reference deals with two commencement orders. They are each the same in terms of their architecture. The first of those orders is at tab 10, the second is at tab 11. It may be worthwhile turning briefly to the first of those at tab 10 to see the way in which this was done.
If this had been a publicly available resource, in other words, the long postcodes had been compiled in some publicly available facility, and recourse had been had to it by the DWP, there would be no question of a devolution issue arising. Isn't that right?
I think that's right, my lord. The question arises in this case because the postcodes were issued.
Yes. Well, they were prepared, I think, and issued by the DFC. But it might appear to be somewhat contrived for the attorney to latch on to the happenstance that the DFC happened to prepare this long postcode list. And if that hadn't happened, there would be no possibility of him referring this matter to the court.
Your lordship's quite correct that this could have been done without the involvement of the department, and in subsequent commencement orders it has been done without the department taking action. That being said, my lord, I would not accept the characterisation of what the department did as happenstance, because in my submission the lists were prepared and issued for the specific purpose.
No, I'm not suggesting that that was the happenstance. The happenstance arises because the attorney is able to latch onto, without using an unduly pejorative expression, latch onto the circumstance that the DFC did prepare the list. But I mean, your point is, well, whatever the reason for it, this clearly is facilitating at least the exercise of the function, and it's definitely an act that is involved, and whether it's contrived or not, legally you're entitled to draw it in aid.
I think on behalf of the attorney I would be obliged to say that the attorney would not regard the reference as contrived, but rather as an exercise of the role conferred upon him by the 1998 Act.
I don't think we need to get into that particular debate.
So, my lord, I was addressing the question of the Act for the purposes of this reference. We were looking at the first of the two commencement orders, which is at tab 10 of the bundle, and the court may wish to note the particular parts of the interpretation provision, which is Article 2 of that commencement order. On the second page, which is MS 700, the department is defined as the Department for Communities. On the next page, MS 701, list of the number one relevant districts means the list of the number one relevant districts issued by the department on 25 September 2017. And number one relevant districts means the postcodes specified in the table in the list of the number one relevant districts. Those become relevant to commencement under Article 4 of this order. with Article 4.3 providing that the day appointed for the coming into force of the provisions of the 2015 order, which is the Northern Ireland Welfare Reform Order, listed in Schedule 1 as so far as not already in force, is the day appointed in accordance with paragraph 5. And there is reference to paragraph 4, which defines the nature of the claims that are subject to that order, and those include, taking 4A, a claim for universal credit made on or after 27 September 2017, etc., where on the date on which the claim is made, the claimant resides in the number 1 relevant districts. And so it's the attorney's submission that it is the issuing of the lists that makes effective this regime in combination with the commencement order itself. Now, the attorney's position is that it is enough to constitute an act of the department for the purposes of Section 24. That the department's action made effective universal credit and the two-child rule for those living in the first place, the number 1 districts, and in the second order, the number 2 and number 3 districts. However, in my submission, my Lady, my Lords, the department's involvement went well beyond simply putting together and publishing lists of postcodes, and the implementation exercise involved joint action between the department and the DWP, and the involvement of the department is set out in Ms McCleary's affidavit, which is tab 7 of the preliminary hearing bundle, and I would invite the court to look at that affidavit now. It's at MS 293. I would begin, my Lady, my Lords, at paragraph 21, which is MS 297, where it is said that at an operational level, DWP and DFC liaised to plan for the delivery of universal credit in Northern Ireland.
Sorry, which paragraph is that?
It's paragraph 21, my Lady. It's at the bottom of MS 297. And then it said on the next page at paragraph 23 that the next thing that happens is that on the 9th of November, and that's the 9th of November 2016, the then Minister for Communities was briefed, and he was briefed by Mr O'Reilly, who was the Deputy Secretary in the Department for Communities. Now, the full briefing is at MS 392 to 411, but the key point from that briefing is repeated in this paragraph of the affidavit, and that is that agreement had been reached with the DWP that universal credit would be implemented in Northern Ireland on a phased geographical basis between the two dates given. And in my submission, that's an indication of the involvement of the department, rather than as a passive recipient of this regime, an active participant in its implementation. The briefing, I've mentioned the full briefing, I won't take the court to it, but at MS 396, the briefing also uses the language of our proposals for the rollout, and in relation to the pace of the rollout, there is reference to we have also reflected our own thinking in terms of the sequencing of the offices. Then at paragraph 24, there is narrated the statement made by the then Minister on the 6th of December 2016. And again, the key terms are reflected in the affidavit itself. The Minister was pleased to announce that agreement had been reached on the rollout plan. The schedule with office locations had already been agreed, and that schedule had been placed in the Assembly Library. And I think the reference to the Assembly Library is not in the quotation at paragraph 24 of the affidavit, but it is contained in the full statement, which is MS 410, if there is any question about it. At paragraph 27 of the affidavit, it is said that the role of the DFC in relation to the timing of implementation was to provide recommendations to DWP. But there is then a discussion about how the choice of postcodes came about. And at paragraph 29, which is MS 300 to 301, it is said, amongst other things, that DFC, so the department, therefore decided that in some areas in Northern Ireland, territories should be defined on a street-by-street basis. And read plainly, this suggests the department, again, not having a passive role, the implementation being something done to it, but something done with it. And that process of collaboration...
Excuse me, would
yes,
there be a specific Northern Ireland reason for doing things on a street-by-street basis?
there are, my lady, and they're dealt with in brief in the affidavit itself. The issue, my lady, is to do with community relations, that if you define the areas by reference to less specific or granular postcodes, individuals may be in a position where they're visiting offices in areas that are not...
Okay, they may be required to go into an area which they might find hostile.
Indeed so, and that's explained in greater detail in some of the emails appended to the affidavit, but that is in short the reason for it.
Well, I was assuming there was
Yes.
something to that effect,
Yes.
but thank you.
So that process of collaboration led to the mechanism in terms of which the Secretary of State made the commencement orders, but relied, in order for those to have any meaningful sense or practical effect, on the issuing of the lists by the department. And in short, in my submission, without the lists, the rollout would not have had any effect. Now, the issuing of those postcodes is described by the department in its response to this reference as a necessary link in the legislative chain. That's at MS 39. But it nevertheless contains that it is not an act for the purposes of section 24. Now, in my submission, guidance on whether what was done by the department was an act can be drawn from the approach of the Privy Council in Her Majesty's Advocate against R, which is at tab 1 of the authorities. Now, clearly, that's a case dealing with section 57 of the Scotland Act, and there are, of course, differences between the Scottish regime and the Northern Ireland Act, but on this point, the architecture is the same. Section 57 follows the same structure and language as section 24(1)A of the Northern Ireland Act, so far as convention rights is concerned. So no power to do an act which is incompatible. And Schedule 6 of the Scotland Act, which deals with the definition of devolution issues, on that paragraph 1D is equivalent to paragraph 1A of Schedule 10 to the 1998 Act. So whether a purported or proposed exercise of a function by the Scottish Government is or would be incompatible with convention rights. Now, in this case, the board was dealing with a submission on behalf of the Lord Advocate that the word act ought to be read restrictively in the context of the prosecution of offences. And the submission that was made on behalf of the Lord Advocate was that the word did not embrace any of the acts inherent in the proceedings themselves, such as serving an indictment, calling witnesses, lodging productions, or inviting the court to take particular procedural steps. That's narrated by Lord Hope at paragraph 39. And it should also be noted in that case, my lady, my lords, the Lord Advocate was contending for a narrower reading of Act in the Scotland Act to that which the Lord Advocate contended applied under the Human Rights Act. Now, in this case, the Department is contending for a narrow approach to the word Act, not only under the Northern Ireland Act, but under the Human Rights Act as well. The Lord Advocate also relied on the reference in the definition of devolution issues to the exercise of functions as suggesting that the word act should be given a narrow meaning. That's Lord Hope at paragraph 44. Now, on the proper approach to the word act, I would take the court to the judgment of Lord Hope at MS 506. So beginning at paragraph 43,
We have to bear in mind this decision was subsequently disapproved,
my Lord,
departed from.
in certain respects, but my Lord, in my submission, the way the court approaches the question of act and the
Yeah,
breadth of
that's
the
very
expression
broad.
act is appropriate for this case. I would simply observe that Lord Hope takes the view that the question is simply one of statutory construction. He refers in his judgment to specific other provisions of the Scotland Act which support a wider interpretation of the word act. And he refers to the fact that Parliament had made a deliberate choice in creating a parallel scheme to the Human Rights Act 1998 under the devolution legislation for the protection of convention rights. And he rejects at paragraph 46 the suggestion that act in the Scotland Act should have a narrower meaning than under the Human Rights Act. On that point, I won't take the court to it. I would also refer to Lord Roger at paragraph 117. Lord Roger's unequivocal that what constitutes incompatibility with a party's convention right must be the same under both the Scotland Act and the Human Rights Act.
Well, he goes on to define incompatibility in terms that would certainly be a questionable application here. The way he puts it at paragraph 140 is when Parliament refers to a public authority acting in a way that is incompatible with the convention right, it's referring to a public authority violating or infringing a convention right. So if the act of a public authority involves an infringement of a convention right, that act is incompatible or inconsistent with that right and is accordingly unlawful. I mean, I suspect you may say this is an issue for another day, but there's obviously a question as to whether the publication of a list of postcodes infringes or involves an infringement of anybody's convention rights.
I will say that's for another day, my Lord, but what I would also say is that is the way that Lord Roger addresses the question of incompatibility. It's not addressed in quite the same way by Lord Stein and Lord Hope, who refer to inconsistency with a convention right as the test of incompatibility.
Well, yes, that's certainly Lord Hope. Lord Stein, I think, talks about the question being whether the act is precluded by the convention right.
He also, my Lord, talks about the concept of inconsistency with.
Yes, well, that's
right.
That's the same. It's the same issue. Whether a list of postcodes being published is inconsistent with anybody's convention rights is certainly an arguable question.
My Lord, perhaps at this point I should address the third of the questions from the department's case that I was going to come to, which is the question of whether this has independent legal effects, because I think it is part of the question that is troubling your lordship. The attorney does not say that the issuing of postcodes in a vacuum could have any effect so as to breach convention rights. It's clear that the attorney's position is that it is the issuing of these postcodes in the wider legislative context and in the knowledge that in doing so it was going to bring into effect this regime.
Well, your argument is that it was really integral to the successful operation of the scheme. But as my Lord says, this is probably not a debate that needs to be gone into in any depth at this stage.
I'm content to move on if your lordships are. And my lady, I wouldn't say more about this case other than that in my submission it reflects a broad approach by the court to the concept of an act for the purposes of the devolution scheme. I would mention Lord Clyde's judgment at paragraph 89, simply because he deals with the question of exercise of functions. He refers to the fact that the definition of functions expressly includes powers and duties, and to him it is obvious that the exercise of a power may involve the doing of an act. Now, in the time left to me, I would just address those points from the department's case that I said I would touch upon. The first is that it is said by the department that the lists were an expression of its recommendation to DWP about how and where to commence the introduction of universal credit in Northern Ireland. That's at paragraph 32 of the Department's case. In my submission, that's not borne out by the affidavit, to which we've already looked. And in my submission, it's not borne out by the drafting of the commencement orders, which relied on action being taken by the Department to make the rollout of universal credit operational. The second point, and this is from paragraph 38 of the Department's case, what's said by the Department is that the phrase act within both the Human Rights Act and the Northern Ireland Act must mean conduct on the part of the state which is capable of giving rise to an interference with or infringement of convention rights. And for this to occur, it must be conduct which has legal effects. Now, I'm not entirely clear what the Department intends by that submission, but I assume that they mean that we must be dealing with action that has legal effects over and above the breach of convention rights itself. Because clearly a breach of convention rights has a legal effect. There's a short and a long answer to that proposition. The short one is, in my submission, there were legal effects. And the long answer is that it's unsound in my submission as a proposition of law. It's not supported by authority. It's not supported by the approach taken in Her Majesty's Advocate against R. And it's not supported by straightforward examples. One can imagine the state subjecting a person to torture or inhuman and degrading treatment, such as to give rise to a convention breach, but without otherwise affecting the legal relationship between the tortured and the torturer. I would pick up here, just before I go on to the other point, that the Department says that the lists were not prepared pursuant to a statutory or other power. Now, the Department's presumably not contending that it did not have power to compile and issue the lists. It dedicated substantial time and public resource to the implementation of this scheme, and it presumably therefore accepts that it was doing so in the exercise of its functions. I'll leave the Department to address that question. And so far as the question of independent legal effects is concerned, I have addressed that already in my submission. An act need not have independent legal effects for it to contribute to or involve a breach of convention rights, and we can think of cases in which convention breaches are contributed to by more than one public authority. As to the proposition that the lists were wholly dependent on the commencement orders for legal effects, one might equally say that the commencement orders were wholly dependent on the issuing of the lists for legal effects. Both are required for universal credit to be implemented in the relevant areas. And finally, the Department takes the position that the remedy which the attorney seeks is not a remedy that it can afford. The attorney, in a reference of this sort, as the court will be aware, the remedy which the attorney can seek, and the only remedy the attorney can seek, is an answer to the questions which are posed. And if the court was to find that there was a convention breach, then the attorney would expect that both the United Kingdom government and the Department would take the appropriate action to remedy that. Lady and Lords, those are my submissions on behalf of the Attorney General.
Thank you very much indeed, Ms O'Neill. Thank you. Dr McLean.
Lords, I appear in this current on behalf of the Department for Communities. When this reference was received on the 8th of February 2018, the Department invited the Court to consider whether or not a devolution issue had properly been raised and whether or not the paragraph 34 reference power was properly in play. Since we raised that point, this Court considered the exercise of the paragraph 34 power by the attorney in December last year in the reference that was made in respect of the related Buick litigation, and the Court has a copy of its decision. in that case at MS 577.
We didn't reach any firm conclusion.
No.
What's
No.
the...
Kick the can down
Kick
the road.
the can down the road.
Well, as so often happens, the court foreshadowed it was an issue it may have to return to,
Yeah.
and we have had to return to it. But
The can is fixed now.
yes,
And
we
kick further down the
we
road.
trust the can is firmly fixed for today's purposes. But interestingly, in the course of that ruling, Lord Kerr gave the leading judgment. The court recognised that the capacity to make a paragraph 34 reference was not open-ended, that there was, at least for discussion on another day, scope for consideration of the circumstances in which it was proper to make such a reference. The court has that decision at MS 577, as I've indicated. The observations are made by the court. It's in tab 3 of the authorities bundle at paragraph 26. So the court's view was it's not necessarily an open-ended facility, and it's a matter that would require consideration as to when such a reference can properly be made, but recognise that that might be an issue that needs to be addressed in the future. In the discussion, paragraph 28, this court recognised that it's in general desirable that issues of this nature be determined against a clear factual matrix rather than by reference to theoretical or academic issues of law. And the court was clearly of the view there was some importance to be attached to that. In this case, interestingly, this court has granted leave, permission to appeal in respect of a challenge to the two-child policy in the case of SC and 8 children. We're not sure when the court's intending to hear that appeal, but the issues in respect of the policy are live before this court. And they were also live at the point when this reference was originally made in February 2018. The first instance case was heard by Mr. Justice Ousley on the 6th and 7th of February 2018. This reference was made on the 9th of February 2018. So at the point when the reference was made, there were extant proceedings in the United Kingdom raising the question of the convention compliance of the two-child policy. Indeed, those proceedings went on to the Court of Appeal to a further determination and are now listed to be heard before this court. So the scenario we're faced with here is analogous to that which arose in the reference in December 2018.
And of course, the further irony is that the attorney could apply to intervene in what I might describe as the English proceedings.
Precisely, my Lord. That was an issue that was raised last year. One of the lines of argument that the attorney ran in December last year was that he only had capacity to intervene where there was an extant devolution notice.
Yes, well, I think
the court dealt with that in paragraph 29. And of course, we know that the attorney can intervene in cases in England or Scotland where devolution issues are not in play. Both my Lord Kerr and my Lord Reid sat on the panel in the AXA versus Lord Advocate decision in 2011. I think it's UKSC 46 is the reference. That was a case in respect of the plural plaques legislation.
Yes.
Scottish legislation was introduced in 2009. Insurance companies challenged it on the basis of convention breach. The Northern Ireland legislation was introduced in 2011. The Attorney General for Northern Ireland sought a direct reference to the Supreme Court to challenge it. And he withdrew the reference and then participated as an intervener in the AXA and Lord Advocate litigation. We say there's no reason why the same approach could not be adopted in respect of this litigation. And in that case, of course, the utility was served because the Northern Ireland Department participated as well in the litigation in respect of the Scottish circumstances. So
yes,
we say...
that's all very interesting by way of background, but the issue that we are asked to determine here is whether there is a devolution issue, not whether it was proper for the attorney to have resort to his paragraph 34 power.
Well, we'll come to that, my Lord. I accept that is the core issue, but Our submission,
There's an exception in the Act if a devolution issue is frivolous or vexatious.
yes,
That'd be going a bit far, perhaps.
I'm not contending for that, my Lord, but rather I'm contending that this court, in the exercise of its case management powers, looking at the scenario before it and the fact that there is, as it prefers, a factual matrix to be considered shortly, might well consider that the better approach is for this reference to be dismissed and the attorney to be given leave to intervene if he so seeks.
Have we any jurisdiction to dismiss it?
Uh,
If it does raise a devolution issue, have we any jurisdiction to dismiss it?
Interestingly, last year when we had this point, the court didn't dismiss the reference, the court simply adjourned it.
This is true. Yes.
Indefinitely to see what happened next. So the court could, I can confidently say, do what it did previously and adjourn the matter until the outcome of the related proceedings.
But I think my lady is right. It's very difficult to conceive that we would have the power to dismiss this because, as I keep saying, this is an application to us. At least we have required the preliminary issue to be tried, whether it is a devolution issue. We've got to grapple with that.
Yes, and
What we do thereafter is another question.
yes,
But we can't dismiss the preliminary issue that came to us because we decided it should be dealt with in that way.
There are obviously case management things that could be done in relation to the English proceedings, if we can call them that, and what the fate of this reference should be in connection with those. Should it be dealt with together or separately or adjourned until after that's been dealt with, or the participation of both the attorney and the department limited in some way appropriate to the scale of the issue in Northern Ireland. There are all sorts of things that could be done in relation to those proceedings.
I recognise the court has all the levers. It needs to adjust the course appropriately. We say, though, that this department, the Department for Communities, should not be a participant in these proceedings. And this comes to the devolution issue. Because we say, as a matter of law, the Department for Communities has no functions in respect of welfare reform in Northern Ireland. And that, we say, provides the answer to whether or not this is, in fact, a devolution issue.
Well, it leaves a rather curious lacuna in the legislative regime to protect human rights in Northern Ireland if a department can actually do things which may be incompatible with, on ex officio, let's say they've done something which is incompatible with human rights. That you say it falls outside the scope of the legislation because it isn't within the definition of a function.
Well, we say that insofar as we accept there is a function being exercised in this context, we say the function is exercised by the Department for Work and Pensions. And we say that arises as a result of the primary legislation enacted by Parliament, which expressly removed the Department for Communities from the scheme and replaced it with the Department for Work and Pensions. They have the functions. I can show the court fairly crisply, I think, how this came about. The court has the general background to the Northern Ireland policy problem. I think it's in our written case, but for a very pithy summary of it, I would refer the court to MS 632, which is a explanatory note to the Northern Ireland Welfare Reform Act 2015. And I won't take the court through this in the interest of time, but paragraphs 3, 4 and 5 on page 6, MS 632 set out the problem, which was the Northern Ireland parties were not prepared to implement welfare reform. They struck a deal in terms of the Stormont House Agreement saying they would implement welfare reform. Then the Assembly refused to pass it. Then we had a situation where, in light of that, the Northern Ireland budget was being depleted by £9 million per month because they hadn't passed welfare reform. So the matter was then dealt with by way of legislative consent motion, which allowed for the bill that the Northern Ireland authorities would not pass to be introduced through Westminster. And that's what happened. One sees the Northern Ireland Welfare Reform Act at MS 628. So the policy background set out at 632, the court can peruse that at its leisure. But Parliament enacted the Northern Ireland Welfare Reform Act of 2015. Section 1, subsection 2 on page 628 empowered the Majesty to make, by way of order in council, an order in council conferring power on either the Secretary of State or a Northern Ireland Department to make provision for welfare reform. And that was a time-limited power to extend to the 31st of December 2016. The order in council was duly made. That's MS 639, the Welfare Reform Northern Ireland Order 2015. The court will see at MS 643 the transitory provision until such date as the Secretary of State may, by order made by statutory instrument, appoint a function conferred on a Northern Ireland Department to make regulations or an order under this provision is to be exercised by the Secretary of State rather than by the Northern Ireland Department. So the Northern Ireland Department, DFC, is taken entirely out of the equation, disempowered. It has no capacity to deal with the issues in respect of welfare reform until the Secretary of State duly appoints. And the court will also note that for our purposes, MS 641 is relevant. The remaining provisions of this order come into force on such day or days as the Department may by order appoint. And for the Department, one there reads the Secretary of State. So, the operative legislation that brings the two-child limit policy into effect is the Article 15 and 15A of the same order. That's MS 651. So the responsibility for children and young persons is dealt with on that page. Article 15.1a was introduced by another order in council, also made by Her Majesty, and that is the critical provision that imposes the maximum 2 persons limited for eligibility. So all of that was done by way of order in council from Her Majesty. There were then exceptions introduced by way of regulations. There were 2 sets of regulations that introduced particular exceptions. Those regulations were made by the Secretary of State, not for Northern Ireland, the Secretary of State for Work and Pensions. So none of the operative policy functions were discharged by the Department for Communities, nor could they have been, because it was...
I think that's clear enough, but the argument against you surely is that this scheme could not have come into effect without the preparation of the long postcodes. And that was integral to the scheme, and it was the responsibility of the department, not of the DWP. Although I think it now is the DWP that does the work.
Yes.
It's an ex abundante step taken.
Yes, the postcodes in the subsequent commencement orders were issued by the Department for Work and Pensions.
Yes. Right.
The 2 impugned commencement orders had lists of postcodes prepared by the Department for Communities, which were lodged in the library of the House of Commons by the Junior Minister for the Department of Work and Pensions. So the action, the operative action of putting those in the public domain, we say, was that action.
Yes, but it had to be compiled first of all.
Yes. Question, my Lord, I think at that juncture is when one looks back to Schedule 10, paragraph 1b, it constrains functions. The primary purpose is to constrain the discharge of functions. So we pose the question rhetorically, what functions in the proper sense were DFC empowered to exercise? The answer to that is none. They were not exercising any functions because Parliament had intervened to disable them from so doing, and in fact had identified that the correct source of the discharge of functions was the Secretary of State for Work and Pensions. As the evidence shows, everything that flowed of policy significance flowed from the Secretary of State for Work and Pensions. What happened in respect of the Department for Communities was the publication of a list in order to meet a Northern Ireland idiosyncrasy, which otherwise wouldn't have applied. Indeed, we say the fact that DWP subsequently continued the rollout of universal credit by issuing the list themselves demonstrates that they were issuing and exercising all the operative functions in this context. So we say when one looks at Schedule 10, looks at the constraint in Schedule 10, paragraph 1b, it is directed specifically at functions. And we invite the court to adopt that analytical technique to reach the conclusion that here, given that a public authority is disabled from exercising functions, it cannot give rise to a devolution issue. We say that's tacitly recognised by the attorney whenever he was preparing to mount this reference, because the court will see from the exchanges of correspondence that took place that, in fact, he recognised before the reference was lodged that the Department for Communities were not empowered to do anything about this issue. And you will see this, my lady and my lords, in the exchanges of correspondence. I won't go to all of it, but the court will find it between MS 196 and MS 211. So this begins in November 2017. The correspondence is first directed to DFC, raising an apparent devolution issue. DFC reply on the 14th of December 2017, that's at MS 200. And they point out to the attorney you'll see at the last paragraph on MS 201, that the operative provisions were as listed above. None of them are enacted by the Northern Ireland Assembly. None of the statutes are made by a Northern Ireland Department. It's clear that no devolution issue arises. And then they set out what they did do, which was provide a list which was linked by hyperlink in an explanatory note to the commencement order. The attorney then meets with the department, writes to them on the 12th of January 2018, MS 205. He proposes a solution at MS 206, and you'll see in the second paragraph of that, he's suggesting that this court will read in words to the 2015 order in order to deal with the issue he raises, but appreciates the department's not currently empowered to initiate legislative reform. It might wish to share the attorney's view with the Secretary of State as to how this might be taken forward by him. And he refers then to a possible amendment to the legislation. So the attorney is recognising when he's engaging with the department that they can do nothing about this. They have no function to deal with this. And he thereafter corresponds with the Department for Work and Pensions. And one sees that.
Well, it's not in debate that the Department for Communities did not have the power to make the necessary legislative measures. I mean, that's not the debate that's being had here. The question is whether in preparing and making available the lists, it was exercising a function in relation to the implementation of the legislative provisions. And, I mean, it's not the primary function by any means, but can it be said that it's not a function? It's indispensable, is it not, to the successful implementation of the scheme?
Clearly not indispensable, Lord, because DWP were thereafter able to do it alone without them. They could have done it by using
codes. It was not indispensable in the sense that it couldn't otherwise be done, but the preparation and provision of the postcodes was an essential part of the implementation of the scheme as it existed originally. Is that right? It was, yes, Lord. It was an element that was required in order for this to take effect. And that element, or possibly that function, was performed by the DFC.
Obviously, we don't dispute the fact that they compiled the list. That's evident. Question, moving from functions to acts, the submission we've made in our written case is that really when one interprets the word act in Section 24 of the Northern Ireland Act, one reflects on what that's meant to constrain. One reads it with Section 6 of the Human Rights Act, and it takes its meaning from that provision as well. It's meant to constrain breaches or infringement of convention rights. And our submission here is that the compiling of the list to which the legislation pointed was not in itself an infringement of any convention rights. In fact, the substance of what the attorney complains about is the two-child policy. The two-child policy was never formulated by the Department for Communities.
Well, there may be an argument as to whether it's an act which is incompatible with convention rights, but are you denying that it's an act at all?
Well, it's an act that doesn't have itself, we've said, independent legal effects. It is a...
But an act within the meaning of Section 24.
Yes. We say that must be construed. It's not any ancillary activity by a department. The term must have a specific meaning, and we say it draws its meaning from the broader context of the Human Rights Act. So one looks to see whether or not the compilation of this list had in itself any independent legal effects in respect of compatibility or infringement. And we say the answer to that is no, because what actually gives rise to the compatibility question is not that list, but it is the application of the policy elements, all of which were devised and provided by either Parliament or by Order in Council or by the Secretary of State for Work and Pensions.
I wonder if that's perhaps going to lead to confusion of thought. For example, there's been a Scottish case about whether it was lawful to recall prisoners who had been released on licence. And the argument was no prisoners could be recalled from release on licence when there was an election pending, because they wouldn't be allowed to vote. And so the recall of a prisoner would result in an infringement of his convention rights. And the way the courts dealt with the point was to say that the test wasn't one of but-for causation. The recall of the prisoner was not in itself incompatible with the convention right to vote. And you had to focus on that legislation concerned with elections. That was what you had to direct your fire towards, rather than the recall of the prisoner under the penal legislation. But nobody would dream for a moment of suggesting that the recall of the prisoner wasn't an act within the meaning of Section 24 of the Northern Irish legislation or 57 of the Scottish legislation.
Yeah, well, I think...
So you can have an act for the purposes of Section 24, notwithstanding that it may be perfectly compatible with convention rights.
Yes, sorry, I think I agree with that submission, Lord. Yes, there can be an act. We accept here that there was an activity. We accept that an argument we made about it, but we say all the operative relevant actions were taken by a body other than the Northern Ireland Department. That doesn't mean there's an immunity from challenge or a lacuna, which was the concern my Lord expressed earlier, because all of this can be properly directed at DWP, because there's already a case dealing with these very issues, and the very policy in question is under challenge. So we say, we don't use the language of a contrivance, but we say it's unnecessary for this reference to be considered in this way, and it's unnecessary to characterise what has happened here, which is an activity by the department that's probably giving rise to a devolution issue. And it is, we say, significant that paragraph 2 of Schedule 10 does allow for a filtering or a screening by this court. The language there is of frivolous or vexatious reference. We're saying that's not the case, but there must be circumstances where the issue or the act, if any, is de minimis in the grander scheme of things. And we say there can hardly be a better example than having a hyperlink that points to a list of already existing postcodes as a de minimis discharge of a function by the Northern Ireland Department for Communities in circumstances where if they did not provide the information with universal credit coming, then social security systems wouldn't function in Northern Ireland. So we say this court can properly, reading together the elements of Schedule 10, paragraph 33, which requires us to think about other proceedings, paragraph 2, which allows this court to screen, paragraph 1b, which directs us to functions. Collectively, reading the entirety of Schedule 10, we say permits this court to form the view that certain characterizations of devolution issues involve matters that are so tenuous or de minimis that they ought properly not to be the subject of a reference at all.
Would you suggest that the reference in Schedule 10 to a question whether a purported or proposed exercise of a function by a minister or Northern Ireland Department is or would be invalid by reason of Section 24, if there is in fact no argument that it would be invalid by reason of Section 24, well then there is no question, so there's nothing to refer?
I think the point's clear in that scenario.
Well, are you arguing that that is this case?
sorry, I think I missed the first premise.
Well, I'm trying to put your case rather more simply than you're putting
Yes.
it. Instead of trying to argue the unarguable, which is that this is not an act. The paragraph 1 of Schedule 10 says a devolution issue is a question whether a purported or proposed exercise of a function is or would be invalid by reason of Section 24. Section 24 says Department has no power to make, confirm or approve or do any act so far as the legislation or act is incompatible with any of the Convention rights. And if there is no question that the act in question is incompatible with the Convention rights, because it's, well, you put it had a de minimis effect on what was going on, and there was no real discretion involved in the department, could it be said, well, there's no question?
Yes.
Because the answer's obvious, so nothing to refer.
The lady's formulation has a...
You don't have to take it up,
No,
but
no,
it
but
seems
as
to
it-
me to be a great deal clearer and simpler than that.
Yes, my formulation was perhaps inelegantly structured, but I think, Milady, I'd be quite content to adopt that approach.
And you might say that there has to be a point of substance that needs to be addressed by the court.
Yes, and we say there isn't in this context. There may be points of substance to address, and there will be addressed in respect of the forthcoming appeal. We're not disputing that at all. We're not the policy owner. Mm. In fact, if this case went to the next stage, we wouldn't provide the evidence because Department of Communities doesn't have the policy. It would be Department of Work and Pensions who would provide the evidence. So if we got to the substantive issue, which is why this department was always driven to take this preliminary point, we have nothing to say on the
In
substantive.
fact, I think you said earlier you wouldn't be involved in the proceedings at all, or not involved in them.
We're unlikely to be a participant, whether DWP would invite us to intervene, but we would have nothing to contribute to the debate on the substantive issue.
Yeah, you wouldn't want to.
No, exactly. We don't want to be here, which is...
Well, we understand why you don't want to be here, but you don't want to be in that argument.
Yes, exactly.
Yeah.
And we wouldn't want to weary the court when we have nothing to contribute on it. We're not disputing that there's an issue of substance to be grappled with. Court of Appeal have said so. But it's not an issue that really arises from the publication of a list of postcodes. We say this court should not be diverting its resources into considering that. Lady and my Lords, I think those are our submissions.
Well, we're very, very grateful to you, and we will let you all know what the answer to this is as quickly as we can. To that extent, we can't kick the can down the road. You have to know one way or the other. So thank you both very much indeed. Very clear and helpful submissions.